Hello, and welcome to this lecture today, which I'm going to address the issue of whether recent reforms have politicised the judiciary, the UK judiciary. So before we begin, a few notes, a few words on some of the terms involved. So the judiciary, just to clarify, we're talking about the judges working in the UK. We're particularly interested in the most senior judges, those working in the Supreme Court, and also the Court of Appeal, which is the second highest Court of Appeal in the UK, the Supreme Court being the highest. These are the most powerful judges, and these are the ones with the most direct impact on politics. Secondly, what do we mean by politicised? Really just mean being more involved, more directly involved in the political process, brought, as the saying goes, into the political fray. So this can mean one of two things, I suppose. It can mean judges becoming more involved in making political decisions, which is a process known as judicial activism. But it also might mean politicians actually becoming themselves more influenced by the political process, being subject to political influence themselves. But either way, in other words, politicians becoming more involved in the judicial process. But either way, politicisation refers to a breakdown of the strict separation of powers that's supposed to exist between politics and the judiciary. So this lecture will begin by looking at three specific reforms which are often said to have politicised the judiciary. It will then look at the mechanisms in place to resist politicisation, some of the counter-arguments, if you like. And finally, it will look at some of the other factors politicising the judiciary other than those reforms. So to begin with, three key reforms that are often said to have politicised the judiciary. I'll name them and then we'll look at each in turn. So there's the Britain's relationship with the EU and the growing consolidation of the EU is one, and particularly relevant within that, the Factortame case of 1990. Secondly is the Human Rights Act of 1998, and thirdly is the Constitutional Reform Act of 2005. So let's take each of those in turn and consider how far they've politicised the judiciary. So to begin with, Britain's membership of the EU. Well, the European Communities Act of 1972, which confirmed UK membership of what was then the European Economic Community, essentially made the UK subject to the laws of that community. Since then, the EEC has become the EU and its lawmaking powers have increased. But it was only in 1990 that a clash between UK law and the EU was tested in court. To give you the background to this, the Merchant Shipping Act, passed by the UK Parliament in 1988, ruled that only UK boats, only UK vessels could fish in UK waters. Yet EU law stated that boats from any EU country could fish anywhere in the EU. So a Spanish shipping company, Factortame, brought the case to court to establish its right to fish in UK waters. Now, the UK judges ruled in favour of the company, and which established that EU law would indeed take precedence over UK law in the case of a clash between the two, a conflict. So effectively, this gave UK courts the right to suspend UK laws which violated EU law. Now, opponents sensed the new era of judicial activism, with UK judges granting themselves the right to override laws passed by the elected parliament. However, others argued that the case's significance had been overstated and merely served to clarify the situation which had already existed ever since the UK first joined the EEC in 1972, which is that the UK would have to abide by EU laws. Nevertheless, what the Factortame case clearly did establish was that judges, albeit in very exceptional circumstances, now had a power they never had before to suspend acts of the supposedly sovereign UK Parliament. So this is, if you like, Exhibit A in the argument that judges have become involved in politics like never before. More controversial still, however, has been the Human Rights Act of 1998. Now, this act incorporated the European Convention on Human Rights into UK law. the UK had been a signatory to the European Convention ever since it was first drafted in the 1950s. Indeed, the UK had helped to draft it, but it could only be enforced by the European Court of Human Rights in Strasbourg. And this was a lengthy and often quite expensive process. So by incorporating the convention into UK law, the Human Rights Act allowed UK courts to rule on breaches of the convention. So people who felt their human rights had been breached could now seek justice here in the UK. They didn't have to go to the court in Strasbourg.